in the U.S., the statistics were, according to this law firm that did the survey, was quite shocking. Almost 50% of all marriages in the United States end up in divorce or separation. And 60% of second marriages end in divorce. And 73% of third marriages also end in divorce. Meaning, in the U.S., the pattern is people who divorce, it makes it easier for them to have divorce should they remarry again. And I think it'll be easier to divorce. They'll remarry and then get divorced. And if the statistics in the U.S. will hold true for us, then we'll be seeing more and more divorces. Isn't that in itself essentially bad policy?
U.S. is an outlier because their data are really extreme.
Madam Speaker, may we recognize the next interpellator, the Honorable Paul Daza from the 1st District of Northern Samar.
The Honorable Paul Daza is recognized for his interpellation.
Thank you, Madam Speaker. Will the sponsor yield to a few questions?
Willingly, Madam Speaker.
Thank you. First of all, I know that previous interpellators have focused on the constitutional aspects, but I'd like to put it on the record for myself also, because what was cited earlier on Article 15, which my recollection is the section of our Constitution that deals with family. Is that correct?
Yes, Your Honor.
And, Madam Speaker, the Section 2 that was already cited earlier and in previous questioning, it said that marriage is an inviolable social institution. Now, just to make sure that I really understood that word, I looked it up, and what showed up when I asked my staff to really get the meaning of inviolable is it means never to be broken, infringed, or dishonored. Would that be a fair definition of inviolable?
That is the literal meaning, Your Honor.
And when we interpret, whether it's the Constitution or statutory interpretation, civil code, isn't the literary meaning essentially the first way of interpreting that particular provision? In this case, marriage is an inviolable social institution. I can't see another way of interpreting that. Would there be another way of interpreting inviolable other than stating that it means never to be broken, infringed, or dishonored?
Well, Your Honor, there can be other ways of interpreting that, because this constitutional declaration, as I've said, is not cast on stone. It is a prescription. It is a norm. And when we interpret words in the Constitution or provisions in the Constitution, we should be able to assess the contemporaneous interpretation of those who made the Constitution, and also to read it or interpret it or construct it together with other provisions of the Constitution. So, what was the contemporaneous construction of this provision? No less than the commissioners of the Constitutional Commission of 1986 declared that despite the statement in the Constitution that marriage is an inviolable social institution, Congress can still pass a law on divorce. And if we read the Constitution itself, then there is no provision whatsoever in the Constitution which prohibits Congress from enacting a divorce law.
Madam Speaker, I respect the advocacy and the interpretation of the honorable gentleman from Albay, but having read, this section 15 and, the Article 15, Section 2, where essentially the focus of the framers of the Constitution was to recognize the Filipino family as the foundation of the nation. They essentially made a policy declaration, and because inviolable is not a common daily word that's used, I am sure when they found that word, they meant not to be broken, not to be infringed. And wouldn't that also be a fair interpretation for other members of the House to make? That it says what it says in common lingo, that marriage cannot be broken. And this bill essentially would violate that. Would that be a fair interpretation also of other people who are literally just reading the Constitution?
Well, other people may just make that strict interpretation, but I would submit that the divorce bill or subsequently the divorce law does not violate marriage. Because what is before the family court in a divorce proceeding is a destroyed, violated, and shattered marriage already. As I've already said, what is before the family court is a cadaver of a marriage. But it is not the divorce law which destroyed the marriage that was destroyed prior to the divorce proceedings, because marriage is still a human institution. It is subject to human frailty and mortal misgivings.
Well, Madam Speaker, so I'll move on to my next point and segue to what the Honorable Lagman just said, that many of these families already shattered, broken, and therefore we wouldn't be violating the Constitution if we pass this bill. But my understanding is there are already existing procedures. I'm a lawyer, but I'm not a family law practitioner. But in the family code, we have legal separation and annulment, which is already existing remedies for families that are couples that are having problems. Is that correct?
That's correct, but they are not sufficient to answer problems plaguing couples, particularly wives.
If it's not sufficient, why not just amend the relevant articles of the family code and strengthen the legal separation and annulment provisions there?
We are not in any way amending or even repealing these provisions on legal separation, annulment of marriage, and dissolution of marriage. They are not incompatible with the divorce law. We are giving a fourth option to spouses. But we never intended to repeal these provisions under the family code. As a matter of fact, the grounds under the family code on dissolution of marriage, legal separation, and annulment of marriage are still grounds provided for in the divorce law. But they have been amended to include grounds subsequent to the solemnization of the marriage, because these are causes which are more numerous as grounds for divorce, because these are actually the causes suffered by spouses, particularly wives, during the period of cohabitation, which are not covered by annulment of marriage and the dissolution of marriage, which incidentally, the dissolution of marriage is akin to a canonical divorce under the Roman Catholic Church.
Madam Speaker, to clarify, if a couple, let's say, gets married in church, whether it's Catholic, Christian church, Protestant, or whatever religion, under current laws, to get a dissolution or a legal separation or annulment, could the sponsor explain what the different procedures are in terms of being able to avail of one of the three remedies that's existing now?
Well, the procedure is provided for under the Family Code and the Rules of Court. And the same procedure would apply to divorce proceedings. But we will have to underscore that in dissolution of marriage under Article 36 of the Family Code, the defect should be contemporaneous with the celebration of the marriage, although manifested later. With respect to the annulment of marriage, all of the causes should be at the time of the solemnization of the marriage, not subsequent. And with respect to the legal separation, the separation is from bed and board, and the marriage ties are not severed, so much so that the separated couples cannot remarry. And what happens now is the proliferation of concubinage and adulterous relationship, which are actually punishable by law, but condoned because the couples are not capacitated to remarry. These are the defects and deficiencies of the existing provisions in the Family Code, which this bill would rectify, more particularly with respect to the length and expense of the proceedings in all of these provisions in the Family Code. Because under the Absolute Divorce Bill, it is mandated that it should be expeditious and affordable. As a matter of fact, the judge is required to decide the petition for divorce within 1 year after the lapse of the cooling off period. And then also, there are court-assisted petitioners who qualify, and it is cost-free for them.
Madam Speaker, in a dissolution under Article 36 or annulment under Article 45, under the rules of court, are there any documentary requirements from the church where they wedded to be able to complete the legal procedures in court for either of those two relief that someone can get?
Well, of course, they will have to produce evidence that they are married. Otherwise, there is no cause for dissolution of marriage or annulment of marriage. And the best evidence would be the certificate of marriage.
Are there any other documentary requirements that's needed other than, let's say, that marriage certificate from the relevant church under the current rules of procedure?
Well, I don't think there would be other principal documents in addition to the marriage certificate. But of course, if the ground is for violence or abuse, then most probably a police report can be admissible evidence. If the ground example is fraud under annulment of marriage prior to the marriage celebration, then most probably fraud can be documented and it can be another document. With respect to psychological incapacity, usually the statement of an expert is necessary, but under a new ruling of the Supreme Court, it is not indispensable. But all of this would be a matter of evidence which the petitioner can produce in the family court.
And because the intent of this bill is to establish a fourth mode to get relief from the courts, I'm assuming the rules of court will be similar. Is that correct?
The rules of evidence will not be affected by this bill when it becomes a law. What will be done is that the petition should follow the family code procedure and the rules of court. We did not have to amend the rules of procedure to accommodate the divorce bill. The divorce proceeding would follow the procedures prescribed by the family code and the rules of court.
So, Madam Speaker, if this bill becomes law and the intent was to make it a faster solution for separated couples, if the rules of procedures and rules of evidence say the same, then wouldn't there be similar complaints that these proceedings take too long, it's too expensive? So how is that dealt with in this bill?
Well, as of now, the proceedings for nullification of marriage, legal separation, and annulment of marriage would take so much time. So much so that there are even circumstances when the petitioner or the respondent will already be dead and the case is still pending. How is that resolved or rectified? The provision in the bill says that the action or petition for divorce should be resolved or decided by the family court within 1 year after the expiration of the 60-day cooling off period. That is really expeditious. Then with respect to expense and affordability, the declaration of guidelines in the bill provides that the proceedings should be expeditious and affordable. Expeditious because there is a time frame under which the judge should make the decision, and affordable because there are provisions which would qualify petitioners to be assisted by the court. They will not pay the filing fees, they're not going to pay judicial costs, and they will be given an attorney, a de officio lawyer, and they will be given expert services by the court free of charge.
So, Madam Speaker, if this bill is an optional fourth remedy. Those provisions that the sponsor cited that they think will fast-track resolution of this fourth mode, which is the petition for an absolute divorce, why not also include the other existing three modes, Article 36, 45, and 55, and also include that as an amendment if we really want to help shattered and broken families that need relief from the courts? Why didn't the sponsor include reference to the other articles of the Family Code to help those families?
Well, that will destroy the option. The option is for the aggrieved party to make a decision on what course of action he or she would take. So if she wants it to be expeditious and affordable, then file the divorce petition. It already includes the causes under dissolution of marriage, legal separation, and annulment of marriage as amended. But if the petitioner would like, if the aggrieved party would like to pursue the process under legal separation or annulment of marriage or dissolution of marriage, then so be it. The option is there. Let the party decide.
Yes, I understand that, but to me it's counterintuitive, and in fact, probably may not be good policy if we're going to include language for a fourth option, but not for the other existing three. If our intention is to help, and as the sponsor said, mostly women who are abused, neglected, relationships already broken, why not include the same fast-track provisions for resolution for the existing three, to equalize the options and to allow possible women who want to avail of relief and give them the choices for the four different modes with equal relief and equal speed under the law. It doesn't make sense to me just to favor one.
It makes sense because we are giving an option. If you don't want to take the option, so be it. If you want to file an annulment proceeding, which is lengthy and expeditious, then do so. If you want to file legal separation, and because you are a devout Catholic, and you don't want to get the right to remarry, then do so. The options are there. The aggrieved party should make the decision. We are not going to make the decision for them.
So, Madam Speaker, that would literally mean that if this bill passes, and because there are time periods, I think 1 year, as mentioned earlier, for the court after the 60-day cooling off period to resolve the petition, then it will encourage more petitioners in bias for the fourth option, which is the absolute divorce. So if you're a practicing Catholic and you'd rather, let's say, do legal separation because of your religious beliefs, you will tend to go for the fourth option because it'll be faster. And I think that's bad policy. Where we would be legislating and helping couples, people, to use one particular relief in favor of the other remedies, and it's embedded in the law. And I find something wrong with that. But having said that,
let me just say that the grounds for legal separation, annulment of marriage, and dissolution of marriage are among the grounds for a petition for divorce. So, to my mind, that wide option should be an encouragement for those who are really aggrieved to take the option which is expeditious and affordable. That is a good policy. But the option remains. Give the people, give the aggrieved parties that option. Take it or leave it.
Well, Madam Speaker, I'm of the different view. There should be equal timetables and equal deadlines set. Should this bill pass to give couples more options. But anyways, having said that, I'd like to ask the sponsor. They get the absolute divorce granted by the court. I know in the bill it stipulates alimony and child support. So my question is, under this bill, does it address the situation where a couple gets divorced, the court orders child support and alimony, and I think the bill says up to maximum of 3 years for the aggrieved party. If, let's say in this case where the aggrieved party is the woman, and I admit that that is the case historically, if the man remarries, let's say 6 months later, and then has children with the second spouse, how will that affect the child support order for the first family? Is that addressed in this bill?
Well, the child support subsists whether the party or spouse obliged to give support remarries or not. But we should always understand that support depends on the needs of the persons to be supported and the capacity of the person giving support. So, if a man remarries and have children in the second marriage, then most probably his capacity may not be able to sustain his children in the first marriage and his children in the second marriage. Though now it is now for the court to appreciate whether that capacity would subsist or that capacity has diminished so much so that the support can be decreased. But that will depend on the appreciation of the evidence by the court.
And Madam Speaker, I think that's one of the problems that's essentially pointed out by the other interpreters, that we would be directly encouraging remarriages, because if the absolute divorce is granted, and that affects the existing children of previous marriages. And I'm somewhat disappointed that there's no language or provision that deals with that situation, because mothers and fathers are important for us, family is important for us, but the utmost priority should be the children, and there should be some provision that addresses how to adjust child support when someone remarries later on. Now, for sake of time, let me ask
just say,
sponsor.
Madam Speaker, that if the distinguished gentleman would have some proposed amendments to cover that situation, then we will be willing to hear the amendments and consider the same.
Thank you, Madam Speaker, for that offer. But I'm essentially still not persuaded on the bill, And I'm just only highlighting what I think the gaps that I've seen. And I hope maybe the committee or other members would come up with that. And I would feel somewhat uncomfortable offering any amendments to address that, but I'd like to point it out to the sponsors. We searched, according to a law firm in the U.S., the name of the law firm, it's public information, Wilkinson and Finbeiner, that in the U.S., the statistics were, according to this law firm that did the survey, was quite shocking. Almost 50% of all marriages in the United States end up in divorce or separation. And as we know, I think in all the states, they have divorce laws. 60% of second marriages end in divorce, and 73% of third marriages also end in divorce, meaning in the U.S., the pattern is people who divorce, it makes it easier for them to have divorce should they remarry again. And I think the whole point of that statistics is that may happen here where you have a situation where it'll be easier to divorce, they'll remarry and then get divorced, and if the statistics in the U.S. will hold true for us, then we'll be seeing more and more divorces. Isn't that in itself essentially bad policy? If we created laws that just encourages more separation and more divorces.
Mr. Speaker, first, the U.S. is an outlier because their data are really extreme. So much so that in the statistics being used on divorce worldwide, the United States is not included. Number two, the rise in divorce in the United States was due to the no contest divorce, which President Reagan regretted having signed. But we are not following that in the Philippines. We do not use these quickie divorces as ground for divorce under the bill. Under the bill, no contest divorce, no quickie divorce, no Las Vegas divorce, no notarial divorce, no email divorce. So, Mr. Speaker, Madam Speaker, we do not allow this in the bill because that would really cause the floodgates to open. But with respect to other countries other than the United States, the floodgates for divorce and separation were not open because of legitimizing divorce. The data across the world, except the United States, would say that about only 1% out of 1,000 marriages would result in divorce worldwide, Madam Speaker. So we have not opened the floodgates for divorce. Even in countries where divorce is very lenient, like in Colombia, where notarial divorce is permitted, the divorce rate is among the lowest in Latin America. So we should not fear that divorce law in the Philippines, which is much more strict than the other countries, would result to more divorces because the evidence show that it is otherwise.
Madam Speaker, the sponsor said earlier that he's a good Catholic, and essentially the bill will help shattered, broken families. It will deal with the most aggrieved, which are the women. But from my recollection, I think the Catholic Church and other church-based groups, especially Christian groups, are not in favor of the bill. As a practicing member of whatever religious organization that's not in favor of the bill, like a Catholic, how can we really reconcile that? Because that's one that I'm having a hard time with. I think the intention is good. I applaud the sponsor and the other authors on this. But I think it's the wrong approach and not consistent with what's the ideals of my own church. So how do we reconcile that for the members like myself who are conflicted?
No less than the Pope said that the clergy should be mindful of the rights to the Eucharist of divorced couples. No less than the Pope moderated the cost and time consumed for what is known as canonical divorces based on psychological incapacity of either or one of the spouses. All Catholic countries, all Christian countries, except the Philippines and the tiny state of Vatican, have legalized divorce. This is an indubitable manifestation that divorce does not offend the Catholic faith, that divorce is not against the Catholic dogma. And let me also say that although we respect the doctrines of the Church, we are a secular state, and marriage is still a secular institution. There are more civil marriages in the Philippines than Catholic marriages. And that is the statistics from the Philippine Statistics Authority.
Fair enough, Madam Speaker. Considering the time, I actually have a few more questions, but I'd like to wind up and thank the sponsor for his gracious answers. And I'd like to manifest, if there's a second round, I would like to be listed for the second round. Thank you, Madam Speaker, and thank you to the Honorable Lagman.
Thank you, Honorable Daza. Majority Leader.
Thank you.